Colleagues, in this, our final session, we thought it right to adopt a resolutely prospective view of things, turned internationally out to the diverse world, concerns through the day for pluralism and social diversity have not only shaped our work today, but I think it's fair that these concerns and these cosmopolitanism that's evoked in the title of this panel is part of the Canadian and international legal imagination, is certainly something that is a concern for an apex court like this one. J'ai l'honneur de vous présenter notre modératrice, Madame Hélène Buzzetti, journaliste chevronnée, chroniqueuse politique, fine observatrice de la vie politique canadienne et internationale. Hélène, you're a veritable celebrity, of course, because we see Hélène on television and very often. A Supreme Court judge can walk through the streets of Ottawa, un illustre inconnu. Hélène has to stop signing autographs and to sign autographs in the supermarket.
Depending on which side of the river you're in.
Okay. So you do your shopping in Ottawa incognito.
I'm okay.
Ben, on peut se transporter à Gatineau, vous serez plus à l'aise. Madame Buzzetti travaille, comme vous savez sans doute, au Coop de l'information qui regroupe les journaux, Le Droit, Le Nouvelliste, Le Quotidien, Le Soleil, La Tribune, La Voix de l'Est, donc tout le Québec vous suit à la loupe. Madame Buzzetti, over to you to introduce our panelists for this last session.
Merci beaucoup, Nicolas. Alors, bienvenue à tous et à toutes à ce dernier, mais non le moindre panel. Et cet après-midi, on vous propose un vaste sujet, questions émergentes dans un monde juridique cosmopolite, emerging issues in the cosmopolitan legal world. We have with us today two formidable speakers. First, Donal O'Donnell, who has been sitting on the Supreme Court of Ireland for 15 years now, and who is since 2021 the Chief Justice of the Supreme Court. Et bien sûr, Louise Arbour, ancienne juge à la Cour suprême du Canada, ex-procureure du Tribunal pénal international de l'ex-Yougoslavie et du Rwanda, ancienne haute commissaire aux Nations unies aux droits de la personne, notamment. Alors, Louise nous parlera de la privatisation des litiges, la privatisation du droit et la privatisation de la justice en général. And Donal will talk about the value for apex courts of references to international precedents and the interaction between national and supranational courts. I have to be honest with you. I was terrified at first at the idea of moderating this panel. After all, I'm probably the only person in this room who has not a legal education. I'm only a reporter, not even a judicial one. Et puis, j'ai réalisé, en fait, que ces enjeux, parce qu'on en a un peu parlé avant cette conférence, eh bien, j'ai réalisé qu'ils sont fascinants pour une journaliste politique comme moi, parce que plusieurs de ces enjeux, vous allez le voir, ont un puissant écho dans l'arène politique. Alors, quand, par exemple, comment on peut plaider pour l'influence de d'autres décisions provenant de d'autres pays dans notre système national, à une époque de repli national et de rejet de plus en plus important du multilatéralisme. Comment la privatisation du droit peut-elle miner le droit public et participer donc à cette érosion des institutions à laquelle on assiste et la perte de confiance qui l'accompagne? So, our two panelists have asked that we keep this exercise informal, and it suits the fact that we're the last panel of the day, right? So we'll keep it simple. Alors, chacun fera une présentation d'à peu près une quinzaine de minutes à tour de rôle. Je me permettrai une question à chacun d'entre eux, peut-être demander à l'autre d'interagir, et ensuite, je l'espère, on pourra ouvrir ça aux questions du public. So, over to you. À vous, Louise, on va commencer avec vous.
Merci beaucoup, Hélène. Alors, comme les autres panélistes, je tiens à remercier très sincèrement le juge en chef Wagner et ses collègues de la Cour, non seulement pour avoir organisé cette fantastique journée, mais surtout pour m'avoir invité, qui m'amène dans la grande nostalgie. Alors, je vais vous parler de ça au début. J'ai mis les pieds dans cette salle d'audience la première fois il y a plus de 50 ans, comme clerc du juge Louis-Philippe Pigeon. Et je me souviens très bien d'avoir été assise quelque part là où vous êtes et de me réjouir de la façon dont il terrorisait les avocats. Un style d'ailleurs que j'ai tenté moi-même d'imiter avec très peu de succès. But then I left also this court some 20 years ago. And I have to pinch myself when I realize that it's that long since I've actually sat on, I think, 3 of these red thrones behind me. And I say that because, first of all, I don't want this to be an exercise in nostalgia, and I don't want anything to suggest to you that I have some kind of romantic view of the past. Quite the opposite. I'm very anchored in the reality and in the future. It interests me a lot more than the past. But I say that as a disclaimer because I just realized, listening to the presentations today, that I don't do this kind of work. Well, don't tell BLG. They think I do, but okay, strike that from the record, as the Americans say.
Too late for that.
I do a lot of other things, but I'm not kind of anchored in the day-to-day development of legal issues on the scale and scope that has been demonstrated here today. And even worse than that, I was recently asked by a professor of first-year criminal law to attend his class, and he told me there were 2 of my decisions in particular that he wanted me to discuss with his students. So one, I remember the name. The other one didn't mean anything. I looked them up, and I swear, if it hadn't had my name written on it, I stay with me. It's 20 years ago. You know, just a little water under that bridge. Not only that, could I barely remember it, I could barely understand it. I told the students, this was in January, I said, so you're all first-year law students, yeah? Have you started criminal law in September, or are you just starting now? Because if you're starting now, we may as well wait and talk in a few months. There's no way you could figure that out. I could barely understand it myself. So with this disclaimer, when Nicolas spoke to me about joining this panel, he said, you could talk about anything you want. So I thought I would reflect on an issue that I've raised. In fact, Pierre Bienvenu, who is here. Oh, the first thing I should have said, in fact, right at the outset, that's what I meant to say. I don't want to be nostalgic, but people have asked me, several people have asked me, has this changed since you first were in this courtroom 50 years ago? And I said, not much, except then we had central heating.
Yeah. They already started the cuts.
So when when Nicolas said, just join us and you could, and he said, you don't have to prepare a scholarly paper, just some reflections. So I thought I would revisit in a kind of national context an issue that I addressed a few years ago to the ICCA, what is it, International Chamber of Commercial Arbitration. I didn't know anything about arbitration, but I was asked to address that audience, and I started looking into it. And I voiced some concerns, to make it a short story, basically about whether the growth of commercial and investment international arbitration could possibly have an effect of depleting national systems, particularly in developing countries. And I explored that idea and to what extent is it linked to justice. So basically, the question I'm asking myself now, also in a national context, is whether dispute resolution is really connected to justice. It is often at the end of the process where the courts have to contribute the implementation of the sentence arbitrale. But more profoundly, is private dispute resolution happily private? And if so, does it have anything to do with the development of the law and the connection between the development of the law and perceptions of justice? So it's a little bit that reflection that I wanted to share with you today, and it may have broader implications depending on what conclusions we reach. So, la première chose, c'est que on a des débats sociaux importants puis très robustes sur des concepts de privatisation, par exemple, privatisation de la santé. Au Québec en particulier, je ne suis pas sûre ailleurs au Canada, mais sur la privatisation de l'éducation, c'est un débat qui est assez récurrent. Par exemple, le financement public d'écoles privées, est-ce que l'école publique, ce n'est pas l'espèce de fondement de la démocratie? Dans le système public, la même chose. Est-ce que la croissance des cliniques, dans le système de la santé, la croissance des cliniques privées qui sont supposées alléger le domaine public, donc permettre au régime public d'avoir plus de ressources, est-ce que c'est vraiment ça, sa fonction, et est-ce que c'est vraiment ça les conséquences de la croissance, de la privatisation de la médecine, de la santé? Il y a d'autres domaines aussi où il y a eu de la privatisation. Des fois, je pense aux services postaux qui sont... Alors, il y a toutes sortes de biens publics aux États-Unis. Heureusement, on y a échappé ici, mais à peine. La privatisation du système correctionnel, des pénitenciers, des prisons. Alors, toute cette question de la privation des biens publics ou des services publics, on en discute quand même beaucoup, mais j'entends jamais de discussion sur la privatisation de la justice. Je pense parce qu'on pense que la privatisation de la résolution des litiges privés, ce n'est pas une affaire de justice. Mais alors, moi, je pense que c'est là-dessus qu'il faut réfléchir. Does the entire very sophisticated system of alternative dispute resolution amongst private parties, for the most part, not exclusively, sometimes state actors may be part of that, does that in any way, or should it concern us about having an effect on the public's perception about justice delivery in this country? So let me just maybe give you a little sense of maybe the scale of the issue. So when I was a law clerk for Justice Louis-Philippe Pigeon in the early 1970s, you know, the 20th century, you remember that part? In those days, the Supreme Court of Canada had jurisdiction as of right, without leave being required, on all matters where the amount in controversy was over $50,000. Our court list was the only list we ever reached. It was one called Remanents, something like that. Les causes en retard. And then there was the Quebec list and the 2 or 3 other lists. And we never got out of the first one. But that gives you an idea. Obviously, this is pre-charter. I mean, frankly, to get a federalism case was a treat, you know, compared to this immense volume and then to give you a sense of the context as well, this is before when I reached the Official Languages Act that had just been enacted, but when I was in law school, it hadn't. So this entire environment was almost exclusively Anglophone, but that's beside the point. So the Supreme Court of Canada heard, as I said, as of right, a massive amount of private law disputes. And then I looked at the court's publication for last year. In 2023, 6 cases, 12% of the cases heard by this court were private law cases. And of the 36 appeals decided that year, 2, that's 6%, were private law. And of the 124 leave application, 25% were in private law matters. And while criminal law occupies more than 50% of the work of this court, not all of it comes as of right. As you know, there's jurisdiction as of right, but only 10 appeals came as of right. on the court's docket last year. I say that just to show again, not to be nostalgic, or I'm not suggesting for a minute that there should be a kind of increase in civil jurisdiction that there was in the old days, but it's very striking, and one I think should reflect on the consequences of the work of the court being primarily in public law matters, so criminal, large volume, constitutional, and then to some extent administrative law, which also touches on these kinds of issues. So I'm asking myself, is it because particularly commercial arbitration has occupied such a large space? Maybe it is unconnected, maybe it's for other reasons, but I think it's worth reflecting on where it situates the court and the public sense of the work of the court when we see so much of private disputes not reaching the Supreme Court, and the growth, as I said, of private dispute resolution mechanisms. So if we look at the numbers in arbitration, it's hard to get a full picture, but there's a very good report by, what is it called, the 2024 Canadian Arbitration Report. There are lots of numbers there. It's not particularly significant to go into a lot of details, but some things are very striking. This is based on a survey, so again, it may not reflect the entirety of the scale and scope of private dispute resolution through arbitration. It doesn't touch on mediation, and it touches really on what I would call formal arbitration mechanism, not ad hoc arrangements between parties. What struck me as very significant is that in that survey, it said that when lawyers recommended including an arbitration clause to their clients in contract negotiation, it was accepted in 70% of the time. And when you start looking at the reasons the commercial parties may opt for an arbitration system of dispute resolution, it's the way the questions were asked in that survey, you have to look at a few double negatives, but essentially confidentiality plays a large part. The other reasons are, I think, well known in the literature: cost, speed, as opposed to delay, choice of adjudicator, but I think, again, secrecy or confidentiality plays a large part. I think the concerns in international commercial arbitration are somewhat different than the concerns we may have, concerns or just observations about the effect of this privatization of dispute resolution. Some of first of all, the benefits are very well known. As I said, the parties prefer a regime essentially that they control through the choice of adjudicator, and in a lot of cases, rules that they choose to put in place. The drawbacks are less, I think, well developed in the literature. The most common one, certainly in international arbitration, is the allegation of a possible negative effect on the development of the common law in particular that is so dependent on case law. And over time, a sense that general legal principles will become disconnected from the changing reality of the times of society and so on. There's concerns, and I think that's true both internationally and domestically, about the creation of a highly specialized sort of bench and bar, adjudicators and litigators, who, and again, because only they are privy to the proceedings and the results, become highly specialized. So a kind of elite bar that develops kind of legal issues in this kind of small community where it's not widely shared. I have other concerns. They're not fully articulated, but I'll put them out to you, and maybe you'll be able to tell me if they're real concerns. Again, because I haven't looked at the details of arbitration proceedings, but to me, there could be a question about a lack of opportunity for public issues to be raised and debated as they are otherwise, even sometimes in civil cases before our courts. The possibility for interveners to participate and the raising of either environmental concerns, of human rights concerns, disappears if the proceedings are not part of the kind of public debate, which also has an education value. I'm also concerned about a possibility, or at least a concern as to whether state actors, that is, parties who are subject to the Charter, could shelter themselves through an arbitration agreement from the oversight of national courts. I don't know that it's been raised, but I think one could contemplate an environment in which, certainly I think internationally, that should be an issue. I think if, say, the government of South Africa was to enter into a contractual agreement with a mining company with an arbitration clause where the proceedings are confidential, you might ask whether it's appropriate or even legal for the government to shelter itself from the constitutional oversight of its own court. In a domestic context, I think one could anticipate situations in which this would also occur. And as I said, the fact that the debate is restricted to the parties and does not permit public scrutiny and possibly interventions. So in light of these, I could give you numbers, it's not very significant, about the type of amounts in controversy, the types of cases which typically go to arbitrations, contract interpretation, construction, engineering, infrastructure, manufacturing, corporate and shareholders, disputes, joint ventures, partnerships, and of course, we know there's a widespread use of arbitration and mediation in labor disputes. There are lots of fields in which I don't think we could express specific concerns, but I'm not sure that it's all of them. In terms of let me just address very briefly the kinds of, not necessarily remedies, but initiatives that could be envisaged. In the international context, when I spoke to the ICCA, I think to the shock of some, I suggested that if I'm correct that the spread of high-level international commercial arbitration impoverishes, or I don't know if that's a word, maybe slow down the progress of justice delivery in developing countries, that one possible initiative should be, and I won't call it a tax, I called it a voluntary contribution by all, just as a small percentage of the sentence award. The parties in these arbitration proceedings, certainly the lawyers and the adjudicators, the arbitrators, are usually very well remunerated. Well, if just a small portion could go to a trust fund that could then be used to develop the national justice system in criminal law, family law, the fields that could never be developed sort of internationally. And then a tax if the voluntary system wasn't sufficiently robust. But that, so to some extent, I think if one were to look at real numbers of the private dispute resolution system, which we welcomed in Canada for the same reasons we do in health. That is, it will free up judicial resources. Well, I don't know how one would measure that. I'm not a social scientist, but I don't think there's a lot of evidence that the growth of alternative dispute resolution mechanisms in Canada has produced a vast amount of additional resources for our courts to operate. I've never seen any evidence of that. So maybe just on the financial side, the equivalent of the suggestion I made internationally to recapture some of that could be to have court fees for the l'homologation des sentences arbitrales. What is it called? The thing, the enforcement, of the coming to court at the end of the process to have the arbitral award enforceable. There could be a substantial court fee associated with that, and that's in line with another side of the privatization of justice delivery, which is the increasing number of court fees, from filing to stenography, transcription. I mean, there's an increasing volume of court fees, which, very interesting, we don't have the equivalent in the health system. Dans plusieurs systèmes européens, où on a des systèmes de santé universels, il y a quand même ce qu'on appelle le ticket modérateur et le 20 € qu'il faut payer juste pour prendre un rendez-vous. On n'a pas instauré des mesures similaires dans le domaine de la santé, mais c'est drôle, on le fait dans le domaine de la justice. Des petits frais d'accès à tous les niveaux. Alors, si c'est une pratique établie, ben, on pourrait réfléchir à essayer de recapturer un petit peu de volume de ressources au niveau des sentences arbitrales. Quant à la question de l'appauvrissement du développement du droit, ben ça, il y a toutes sortes de mécanismes qui devraient être mis en place, à mon avis, comme la publication des sentences arbitrales caviardées ou sous forme de résumé, j'allais dire redacted, puis je ne me rappelais pas du mot en français, caviardé, ou bien des résumés, ou bien des revisions par des professeurs de droit, justement, qui pourraient faire des résumés, mais en temps assez réel, si possible, pour qu'on ait le bénéfice du développement des analyses, qui, j'en suis certaine, sont très sophistiquées. Je le sais parce que beaucoup de mes anciens collègues qui font beaucoup d'arbitrage, il y en a même qui m'ont dit « ça me fait beaucoup de peine que le travail que j'ai fait ne soit pas disponible après avoir travaillé dans la magistrature pendant plusieurs années. Puis là, je fais du travail de qualité équivalente avec des très bons avocats, souvent avec beaucoup plus de moyens. Puis c'est un peu dommage que ça ne bénéficie pas au public en général. » Alors voilà, de façon relativement superficielle, la préoccupation que j'ai avec cette démarche de privatisation des litiges, éventuellement de la justice, et l'absence de débat public équivalent à ce qu'on voit dans les autres domaines de ressources de biens publics.
Merci, Louise. Moi, j'ai trouvé ça fascinant, ce sujet-là. Vous m'avez fait lire là-dessus aussi avant aujourd'hui. Toute cette notion d'écrémage, finalement, qui prive le système public d'une sorte d'émulation dont il pourrait tirer profit, en particulier dans les pays qui sont en train de développer leur système de justice. Mais permettez-moi de vous poser, peut-être, de me décoller un peu du sujet et de vous poser une question, peut-être, à titre de journaliste. Vous allez voir le lien que je fais. Mais vous savez, nous, les journalistes, notre grand drame, si je peux dire, c'est que nous avons perdu le monopole du débat public. Nous détenions les moyens de communication. Nous avions les presses, nous avions les ondes, et nous décidions ce qui serait imprimé, nous décidions ce qui serait entendu. Et un jour, il y a eu une généralisation des moyens de communication et nous avons perdu ce monopole. Et avec lui, une certaine perte d'autorité aussi, et s'en est suivi une sorte de perte de confiance envers nous. Et je me pose la question, ce que vous nous racontez, dans le fond, c'est aussi une forme d'atomisation de la justice, qui finalement, où le secteur public n'a plus le monopole sur la justice. Et je me demande, je m'interroge, est-ce que ça peut mener, ça aussi, peut-être à une perte d'autorité de la magistrature, du système de la magistrature en général, et peut-être même une perte de confiance du public envers de ce système?
Oui, je pense que c'est intéressant parce qu'il y a peut-être un paradoxe. On pourrait prétendre, ou on pourrait croire, que si, par exemple, la Cour suprême du Canada travaille, pas exclusivement, mais très majoritairement, sur des questions, je dirais, vraiment d'intérêt public, dans le sens de droit public, questions de charte, questions de fédéralisme, toutes les questions de droit criminel qui ont beaucoup d'écho dans l'opinion publique, qui véhiculent à la fois nos valeurs et nos préjudices, des fois en proportion autant de préjudices que de valeurs. Alors, tout ça pour dire qu'on pourrait penser que si la Cour concentre ses travaux sur des grandes questions publiques, c'est sa vocation. Le problème, je pense, avec ça, c'est que si la Cour travaille presque exclusivement dans ces domaines-là, ça risque de servir à une perception de politisation de la Cour, que c'est un organisme ou un organe de l'État, c'est pas un organe du gouvernement, c'est un organe de l'État qui est moins technique qu'on aurait pu penser. Et on a encore l'espèce de nostalgie que ce que les juges font, ce n'est qu'appliquer le droit. Bon, ça fait longtemps qu'on a franchi ce Rubicon, je pense. Mais si la Cour est presque tout le temps interpellée sur des grands enjeux sociaux à caractère et qui sont souvent très polarisants, et qu'elle fait moins de travail qui est perçu comme plus technique, alors ça peut contribuer, très malheureusement, à une vague assez sinistre, en fait, qui tente de prétendre que les tribunaux sont des instruments politiques, que les juges appartiennent à des idéologies. Bon, on connaît le débat. Alors, je ne sais pas de quel côté ça peut jouer, mais je pense qu'on doit s'inquiéter de quoi que ce soit qui contribue à la perception de la politisation de la justice. Alors, si ça peut être compensé en partie par un output, une production de travail qui est hautement juridique, spécialisée, technique, et qui n'a pas cette saveur plus politique.
Ça diluerait finalement
Peut-être.
Ce qui est perçu comme étant politique. Ouais, ouais. Donal, do you want to jump in before I give you the floor for your presentation?
Thank you, Hélène. I think three different things about what Louise has said. Firstly, from just the business of arbitration and commercial arbitration and contractual arbitration being done outside courts, that's an international phenomenon, and I think it behoves us to ask why that's occurring in the spirit of inquiry of today. And partly, there's no doubt, I think, that court resolution of those disputes is superior. Now, that's not self-delusion. It's if you look at what Daniel Kahneman, Cass Sunstein, and Siboney said about noise, about the random decision-making, that the biggest protection against that is the appellate system, that you run the thing through the cycle twice, you have a better chance of the right result. But it's an interesting thing that the market doesn't value that. It values what arbitration gives, which is a single solution and one in private. And, that asks a question, I think, of courts. And the second thing, I think, is that, again, there's an international phenomenon. It's of private law, of what was done by apex courts 40 years ago. Both my court, Robert Reid's court, was much more private law. And as private law, and certainly private contractual law, has exited, the space is filled by public law, judicial review, output administrative action, constitutional actions, which brings the courts much more into a relationship of friction with the executive and legislative branches. And that's happening at the same time as when the attitude of those branches to the court system has changed and is much more sceptical, if I can use that word. So that's just an interesting phenomenon. And the third thing that struck me when I heard Louise discuss this, or we were talking about it, is the word CETA. Now, CETA is the Comprehensive Economic Trade Agreement that was signed between Canada and the European Union in 2016. And it came across my desk in circumstances which I was astonished, because it was a trade agreement with the EU, but because of EU law, it's treated as a mixed agreement, which means it must be ratified not just by the EU, but by all the member states. And it arrived in our court because a member of Parliament challenged the government's entitlement to ratify CETA. CETA had three components. One was tariffs. And in my innocence, in those days, I thought tariffs was a boring subject. Who knew? But the second component was, fairly standard. It was an agreement to treat each other's products equally, not in a non-discriminatory fashion, and with a right of the parties, Canada or the EU, to bring a claim in that regard. But the third component, and the component that really caused trouble in our court, was a component that allowed individual investors to bring a claim under investor compensation dispute resolution scheme in respect of actions which were administrative, legislative, or judicial, which were prejudicial and which were regarded as either fundamentally unjust or a fundamental denial of fair procedure. It's a very elevated standard. But what you're seeing here is something, a step on from what Louise was describing, which is the privatisation of the resolution of private disputes, and now the privatisation of the resolution of disputes which hitherto were matters of public law. And then what became extremely clever in this whole mechanism was that because it's an arbitration conducted under the Washington and New York Conventions, to which Ireland had adhered, under our Arbitration Act, the determination of that arbitral tribunal had to be capable of enforcement almost without contest in the Irish courts. And so the argument was being made on which the court divided 4-3 and held that the government could not execute this. I should tell you, was in the minority, but the argument was that this was effectively conscripting the system in what was the privatisation of what was a complaint in relation to which ought to have been a core function of the public law system. And I thought and in a sense, everyone agreed that that was something to be concerned about. The question was, have we gone past a significant point? I thought not. My colleagues thought we had. But then when you start to see this, you see it everywhere. And you start to see the privatisation of matters that weren't simply the rolling back of the late 20th century developments, but also the privatisation of issues that were formerly core functions of the government. And what we're seeing with the sacking of large numbers of government employees is an attempt to, or not, but is potentially a challenge to what was hitherto regarded as fundamental components of the state, much as Hélène was saying in the context of journalism. So I don't know what the answer to that is, but it seems to me to be a very important thing to recognise at this time, and for lawyers to be aware of. So I think, I'd like to thank Louise for that immensely stimulating discussion, because it made me think of these things.
Et on reviendra tout à l'heure sur, vous avez parlé de pourquoi cette privatisation remonte, puis on reposera la question tout à l'heure, mais over to you for your presentation about the overlapping of...
I would like to start by really sincerely thanking the Chief Justice and his colleagues in the Supreme Court for the wonderful honour of coming to this great courtroom and speaking to you today. It is daunting. It's daunting to speak to this audience. It's also daunting to be held up as an example of a cosmopolitan legal order. I can tell you that cosmopolitan is a word, an adjective that has never been applied to me in my life. But if you were to marry that with some other adjectives like debonair, perhaps, I might not go home. So thank you very much. As I say, it's a real pleasure to be here. And from the vantage point of an outsider, it may be that there are some interesting things to be said. I want to look at just two questions. One is the question of the place and value of references to international authority in the decisions of Supreme Courts, in this a more rudimentary way than Lionel dealt with, but in the context of constitutional law, where it is particularly sensitive. And the second is, I think, a perspective from, as a member of the European Union, a member in Europe, the interaction between national courts and supranational courts, which is becoming increasingly important. The matter of the use of international precedents by Supreme Courts is a surprisingly sensitive and pressing issue today. Some critics have gone so far as to say that the use of those precedents by Supreme Courts should be prohibited, because they see it as a step towards what they described as, quote, a homogenised global constitutional law representing the views of a largely homogenised legal elite. And that view is allied to a critique of and challenge to the role and function of courts in constitutional decision-making, something that has become more common in recent years, and disturbingly so. I would like to look firstly at the use of international precedents in my own court. We are enthusiastic consumers of foreign precedents, many from Robert Reid's court, but also from the Supreme Court of Canada. And I just want to pick two of those examples because it illustrates something I think that's significant. And to understand this, you must understand that Ireland is a common law country with a written constitution that goes back 100 years. So we're the second oldest written constitution in a common law country with an explicit power of judicial review. and the 1937 Constitution was the first constitution in the world to refer to the concept of dignity and provides for the protection of fundamental rights and enforcement by courts. But because it was part of that early wave and not the post-Second World War wave of constitutional development, it's not the same as the Convention of Human Rights or the International Declaration of Rights or indeed the Charter. It expresses rights in general terms with limitations, and because they're in general terms, they imply other rights which are limited, but it's not clear what those limitations are. So a really fundamental question for all courts is whether any particular legislative provision or indeed administrative decision which may be said to affect rights is or is not an impermissible infringement of those rights. And for many years, Irish courts struggled with that issue on a case-by-case basis, using the traditional but occasionally blunt tools of textual analysis, logic, deduction, and reasoning by analogy, sometimes random consideration of authority from other common law jurisdictions, with results that were sometimes admirable and sometimes less so. And then in 1984, a High Court judge was addressing a question of the constitutionality of a provision in the Offences Against the State Act, and had regard to looked straight to or adopted and accepted the proportionality principle as laid out in Oakes, although not by reference to that case, by reference to a subsequent case. Now, it wasn't inevitable that we would answer that question by reference to proportionality, nor was it inevitable that we would look to Canada, because the European Court of Human Rights already had a proportionality doctrine, and the Bundesverfassungsgericht, the German Constitutional Court, had a very highly developed system. But we adopted word for word the Oakes test, and it was adopted and applied very quickly, which in a sense reflected a discomfort with the law up until then. But very quickly, some perceptive observers pointed out that it wasn't being applied in the same way as it was applied in Canada. It was, in fact, a heightened reasonableness test. And that came to a head during the COVID era, when there was a fundamental challenge to the COVID regulations, and it was said that we should adopt the Canadian principle or approach that once it was established that rights were affected, that the onus shifted to the government to justify those rights. And we had very clear regard and close regard to the Canadian jurisprudence, in particular Peter Hogg's work, and then came to the conclusion that we couldn't do that consistent with a number of established features of the Irish constitutional tradition. So we have a proportionality test with clear Canadian roots, if you like, but with Irish foliage. Now, we have a similar thing that occurred in relation to suspended declarations. A year later, we had a really significant case where there was a challenge to the method of appointment or election of the upper house of the Irish Parliament, and we held that was and had been unconstitutional for 20 years, which gave rise to an immediate problem of how could you cure that. And we had already a sort of embryonic suspended declaration jurisprudence, but we had here a full-scale debate, and we had close regard to both Scactor in Canada and Ontario, the Attorney General of Ontario in G, and again came to a slightly different conclusion. Now, this leads me to ask, what are we to make of this? It certainly doesn't show a homogenized global constitutional law. Indeed, if anything, it shows how, like different grape varieties which are planted in different climates, can produce different types of wine. And a critic might argue, and some have, that actually what's happening here is only a rhetorical cross-reference, which is meant to give an appearance of incontestability because everybody says this, when in fact you're just doing your own thing. I think it's neither. When a court is struggling with a novel issue, which is after all the daily diet of apex courts, a court has to consider the future ramifications and complications of any decision it announces, and must do so within the boundaries of legal reasoning and respect for precedent. And in approaching that task, there's in reality very often very little guidance. And what I value is what somebody with the same responsibilities as mine, with similar trainings and skills and operating under similar constraints, has made of that issue. These are skills which are in short supply, and so when they produce a considered decision, it's really invaluable. But it's not the result which is particularly important, but it's the fact that a part of the terrain has been mapped by a cartographer whose approach and technique is familiar. And from my perspective, therefore, international jurisprudence in constitutional issues is extremely valuable. And interaction with and communication with other national Supreme Courts is to be warmly encouraged. It doesn't make us international judges, but it helps us, I hope, to become better national judges. The second issue is less, perhaps is more complex, because I didn't realize that we were going to be living in an era when the slogan "move fast and break things" would go from being a catch cry of sort of nerdish tech entrepreneurs to becoming a philosophy of government. But there is in that philosophy a hostility to the very idea of regulation and binding rules, which of course challenges the whole idea of the rule of law, involving, as it does, the maintenance of rules and regulations in what is in a rule-bound Western democracy. And I appreciate that recent events, you focus on the assault on your own system. But it is an interesting thing to say that I think post-war Europe is something of a monument to a belief in rules, regulations, structures, rights, and organizations. And it presents in many ways the most advanced supranational regime, which is the embodiment of the belief that a rules-based order can secure peace and prosperity and protect a society from the assault on structures and people that occurred in the 1930s. So the European Convention of Human Rights, on the one hand, was adopted in 1950, and it established a Court of Human Rights to enforce that convention, and the Court permits individual petition, but it still operates at the level of an international law because the parties to the convention are the states, and a challenge at that level or a complaint at that level is against the state and isn't an appeal by the parties from the decision inter se. And the European Union started life in 1957 as an economic community, and the legal order it established was, if anything, even more ambitious because it doesn't merely operate at the level of the member states but becomes part of the national legal system, enforceable by individuals both against the state and sometimes others, and as it has been put, national courts are now also union courts. Now, there's an obvious tension with what happens then with national courts, and both structures seek to avoid that and minimise friction. In the case of the European Convention, by requiring an exhaustion of domestic remedies. In the case of the European Union, because by the route of requiring a preliminary reference to the European Court of Justice on the issue of law, which then returns to the national court for the application of that. And that's seen as a scrupulous division of function, which is repeatedly emphasised. And to some extent, those muddled along, but there's a degree of convergence with the expanding competence of the European Union, and in particular with the adoption in 2009 of the Charter of Fundamental Rights of the European Union, which brought the European Union into the field of human rights protection, at least within the scope of European law. And the drafting of the Charter attempted to minimise the possibilities of inconsistency with the European Convention, firstly because it was expressly limited to the implementation of European law, and secondly because its expression of the rights guaranteed was in many cases similar to, if not indeed identical to, the language of the Convention. And Article 52.3 of the Charter said that where there was that correspondence, the meaning and scope of those rights shall be the same as those laid down by the European Convention, although this would not preclude the Union by adopting a higher standard by law. And all of that is very sensible and admirable, and indeed it is. But multiple documents and multiple jurisdictions create the possibility of multiple decision makers who may inevitably differ. And there's also an inevitable tendency in jurisdiction, once granted, to expand to its limits, if not beyond. And often when issues are raised in litigation in areas where there is an overlap between national law, convention law, and EU law, then a national court may face an argument that a particular result is required by the provisions of the National Constitution, the Convention, or the Charter. And furthermore, the structure which I've identified means that any issue of the law of the European Union must be addressed by way of preliminary reference. Now, putting in place that sort of elaborate structure is a constructive instinct, and certainly the structures created in Europe post-World War II have been admirable and for the most part beneficial. But there is a risk that those buildings which have been so carefully constructed and developed could become a sort of well-meaning Tower of Babel. And there's a point at which being rule-bound can become indistinguishable from being hide-bound, and if so, where the effectiveness and credibility of the entire structure is undermined. And we had one recent case which was a sort of vivid example, perhaps an extreme example, but one area of European development which is very admirable is the European arrest warrant, which allows a warrant to be issued in one European country to secure the return of somebody to that country for trial. And that is executed throughout the 27 member states. And that was so useful, it was one of the provisions retained in the Trade and Cooperation Agreement under which the United Kingdom left the European Union on Brexit, so that it still applies between member states of the European Union and the United Kingdom. So a warrant was issued in 2021 in Northern Ireland seeking the surrender of an individual for trial on very serious offences alleged to have been committed there, and was to be executed, and was executed in Ireland. And then you must then be brought before the High Court. But the legal regime in respect of the serving of sentences in respect of serious terrorist-type offences had been changed in the United Kingdom in 2021, with the effect that a sentence imposed by a court could lead to a prisoner serving more time in prison than they would have had if the same sentence had been imposed as of the date of the offence. And the immediately and undoubtedly difficult question arose as to whether this would mean, whether this would be contrary to Article 7.2 of the European Convention, which precludes or prohibits retroactive penalisation, and also the increase of penalties for an offence from the penalty which existed at the time of the alleged offence, and Article 49.1 of the Charter, which was in identical terms, and it might be said might be contrary to general principles of the Irish Constitution. So there's no doubt it was a difficult legal issue. But when the issue was first raised in the Irish court, the first question was whether it was contrary to the Irish Constitution, because the framework decision requires that nobody can be returned if it's a breach of fundamental rights. So there's a type of renvoi from European law to constitutional law. And imagine that answer being given in the Irish language. The next question for us was whether it contravened the European Convention on Human Rights, which had been incorporated into national law in 2003. So imagine that being debated in French with an Irish accent. And then at this point, a development occurs in Northern Ireland, where the Northern Ireland Court of Appeal deals with a case on exactly the same point and finds that the legislation is in breach of Article 7.2 of the Convention, which is incorporated in the law of the United Kingdom since 1998, since taking effect in 2000. So then there's no question of returning somebody to a state which has held that the legal provision is itself a breach of the Convention which applies. So that pauses things. So imagine that is English with a Northern Irish accent, which I have. And then there's an appeal to Roberts Court, the United Kingdom Supreme Court, which reverses the decision of the Northern Ireland Court of Appeal. English, if you like, spoken, and no offence to Robert, in fact, let's say Scottish accent in deference to Robert. And then it comes back to our court again, and we are told, no, you can't take that decision. We take a different view. We think that they are wrong, and we want you to say that the United Kingdom Supreme Court is wrong on this issue about the application of their own law by reference to the Convention. And also, they said at that point, well, in any event, it's a breach of the Charter. And that required a preliminary reference to the CJEU with an Advocate General's opinion in, let's say, Spanish. And a comprehensive decision from the Court of Justice in Luxembourgish. And when that ruling was received by our court, it didn't cover all the issues, and we made a further reference to the Court of Justice with another Advocate General's opinion, Luxembourgish, and another decision of the Luxembourg Court, which ultimately arrived last week. And that process has not finished because domestic remedies are well and truly exhausted, but Strasbourg has yet to speak, let's say French, pure French, or maybe with a little German accent. And now, what I think is remarkable about this is that this is undoubtedly a difficult issue. Every step on that path is done meticulously, carefully, really impressively, and yet it is 4 years since the issuance of the warrant, 5 years since the alleged offences. Now, that leads me to say here that the difficulty here is not simply the question of delay. The issue that I see here is the risk that this elaborate structure can pose to itself. Because firstly, if we're going to have 8 different versions of an answer to a question which is meant to be fundamental, that undermines belief and credibility in the system. And secondly, there's the problem of simple delay. And therefore, I think the problem we face is not the problem that faced our predecessors in the latter part of the 20th century to build these structures. The challenge is to ensure that the structures established do not unintentionally lead to a form of incoherence, confusion, or stasis, which will inevitably undermine the entire system. And if we are to believe that order is to be preferred to chaos, that the rule-bound state is one that maximizes freedom and the potential for human development and self-realization, then we as lawyers have a particular obligation to make sure that the system of rules operates consistently, compatibly, and effectively with the other components of the legal order and deliver on the promise of human freedom. If I can say so, that has, at its best, has been the legacy of the Canadian Supreme Court over the last century and a half, and it is surely and more clearly our task today. Thank you.
Well, thank you very much, Donal. And I think you illustrate beautifully with this example how this conversation between national and supranational institutions can sometimes lead to very theoretical discussion and also status. And because that's what I want to do, I wanted to bring it back to the realm of politics. But, you know, in the context of rising populism, where we see more and more appeal for authoritarian leaders, it seems that the underlying idea behind that is that many people have come to believe that democracies have not bear its fruits. There is a growing impression that democracy is not able to solve current problems. And what you just explained, it seems to me, illustrates that point. And therefore, I'm wondering if those systems that we're building, are they not part of, are they not feeding that political dynamics of loss of confidence in the system? And what can we do about it?
Well,
simple question.
A simple question. I think there are two things you might say. Firstly, Professor Weber was discussing this, and I should say that these systems in Europe were built to try and resist the very thing we're now facing, not just south of your border, but also in countries like Hungary and Poland. And in fairness, the Court of Justice and the two courts have been very instrumental in slowing down the slide in Poland in particular towards autocracy during the period of the former government, because the court led the challenges to the so-called reforms of the judicial system. So in one sense, that system is working. My point is that we've just got to make it work, because it's too easy to characterize it as, you know, as elitist and inefficient, and I think that's the real challenge for us.
But at the same time, speed is of the essence. And maybe that brings me back to what Louise was talking about. Why this rise in privatization of the law? And one of the reasons is speed, right? Isn't that because there's this impression, or maybe a reality, that maybe the public system does not deliver justice in a timeful manner, and therefore that's why there's this rise. One of the reasons why the privatization is rising. Isn't there a link there?
For
Louise?
One. I'm not sure if speed or the immense delays in these multiple processes is critical, mais je voudrais revenir sur peut-être une expérience un peu personnelle, mais qui fait écho à cette aspiration d'un système plus universel. Quand je suis arrivée comme haut commissaire aux droits de l'homme aux Nations unies, j'avais une espèce d'ambition secrète de faire avancer un projet dont on ne pouvait pas prononcer le nom. C'était la création éventuellement d'une Cour internationale des droits de l'homme. Et je dois vous dire que maintenant, je pense que, non seulement je pense que dans le climat politique actuel, c'est absolument impensable, mais quand je regarde l'expérience dans un système quand même relativement homogène comme l'Union européenne, et puis la difficulté d'accommoder juste au plan procédural les différents niveaux d'intervention, je suis devenue beaucoup plus sceptique. Mais je pense que mon scepticisme a été particulièrement aigu dans un... Je vais vous donner un exemple qui implique le Canada. Au niveau des droits de l'homme, ça s'appelle toujours les droits de l'homme aux Nations unies, alors vous allez m'excuser si j'emploie toujours, mais c'est officiellement, ça s'appelle le Conseil des droits de l'homme, pas des droits de la personne ou des droits humains, ça s'appelle comme ça. Alors, au niveau du système, il y a une idéologie, évidemment, que les droits de l'homme, c'est ancré dans des conventions qui ont été ratifiées de façon presque universelle. Et donc, c'est un droit qui est de portée universelle. Et que tous ces droits doivent être appliqués. Puis là, quand on rentre dans les spécificités culturelles, on n'ose pas faire beaucoup de concessions aux cultures locales qui ne respectent pas, par exemple, les droits à l'égalité des femmes, les droits à la liberté d'expression. Bon. Alors, l'idée qu'on pourrait avoir un organe de nature judiciaire pour mettre en application ces droits fondamentaux en opposant un individu à un État dans un forum vraiment international, c'est de toute évidence très ambitieux. Puis finalement, j'en suis venue à la conclusion que c'est peut-être carrément pas une bonne idée. Je vais vous donner l'exemple de la cause de Adler au Canada. You may remember the issue was whether or not the constitutional requirement, the constitutionally mandated public funding of Catholic schools in Ontario was discriminatory and whether it required an equivalent public funding of all religious schools in the province. The Supreme Court of Canada decided that no, it did not require that. It's a constitutional requirement. It was the deal, the fundamental building of the country together with the protection of religious, denominational right, Protestant rights, to publicly funded education in Quebec and in Catholics elsewhere in the country. So then the issue came up in the Human Rights Committee, which is not a court, but it's the treaty body that adjudicates issues under the International Covenant of Civil and Political Rights. So the Waldman case came before that committee, and that Human Rights Committee found that it was clearly discriminatory for Canada, in this case Ontario, but for all purposes. So for Ontario to fund Catholic schools, fully publicly funded, but not to fund other religious schools. So the committee said, the covenant does not obligate states parties to fund schools which are established on a religious basis. However, if a state party chooses to provide public funding to religious schools, it should make this funding available without discrimination. This means that providing funding to the schools of one religious group and not another must be based on reasonable and objective criteria, In the instant case, the committee concludes that the material before it doesn't show the differential treatment between the Roman Catholic faith and other religious denominations is based on such criteria, and therefore the committee finds a violation of Article 26, prohibition of discrimination. And then subsequently, the Human Rights Committee came back to this, to the appropriate remedy and said, Canada should adopt steps in order to, quote, eliminate discrimination on the basis of religion in the funding of schools in Ontario. Right? So that means an international body would require Canada to have a very fundamental change in its approach to publicly funded education by fully funding religious schools or amend its constitution.
Good luck with
Seriously?
that.
Exactly. So when you see the disconnect between the application of an international norm, which is correct on its face, yep, I think that's discriminatory. But then when you arrive in the Canadian context and you ask yourself, can we and should we live with that, quote, discrimination? To me, the answer is crystal clear. Of course we must. Or we must. I mean, some may advocate the full public funding of religious schools. I wouldn't. In fact, I would advocate no public funding of any private schools of any kind, but that's my own personal views. But the idea, to me, this was obviously not binding, it's not enforceable as such. It's a stain, in a sense, on Canada's human rights reputation in the international system, which then can be used by others to push back on our efforts to advance and promote other human rights. So what good does it serve, contrary to my initial intuition that as the United Nations advocate for human rights, I should promote eventually an International Court of Human Rights, and now I'm thinking, well, you know, sometimes these ideas can do more harm than good. We have to return, I think, to the development, the influence of progressive interpretation of human rights laws by others, but an environment in which either our national or some of our regional courts, where the consensus is much, much more established to advance the development of the law.
Ce que vous nous dites essentiellement aussi, c'est que les droits de la personne, c'est intrinsèquement implanté dans un environnement culturel, social, historique aussi, et que ça ne peut pas être nécessairement toujours normalisé internationalement avec une lentille presque...
Oui, en fait, plus que ça, non seulement c'est vrai, même si c'est la Déclaration universelle des droits de l'homme, c'est quand même un instrument extrêmement universel. Mais ça demeure que les droits humains, ça relève de la relation politiquement très intime entre l'État et je dirais même pas ses citoyens et toutes les personnes qui tombent sous sa juridiction. Cette relation-là qui politiquement est très étroite, là, très intime, je peux vous assurer, ayant essayé de le faire moi-même, c'est très difficile pour un agent extérieur de pénétrer cette relation-là. Ça touche à la souveraineté de l'État et c'est en fait une relation de, là ça me vient en anglais, duty bearer to right holder. Mais le système est géré par les duty bearers, par les États, alors qu'il est destiné à protéger ceux qui ont des droits. Mais c'est une relation culturellement et politiquement extrêmement étroite et intime entre l'État et généralement ses citoyens. Alors, intervenir là, avec un projet, un ordre de niveau supra-étatique, c'est extrêmement difficile.
We have 1 minute left. Do you want to add something to this? Otherwise, I'll ask Nicolas to call this.
No, I think, I suppose the conclusion I would draw really was that we've to learn to resist the natural tendency of lawyers to push the boundaries and to push for that novelty is a value in and of itself. That in this era, it's about conserving the core function. And I feel like there's an analogy which, if you appear in the Court of Justice as I did it's not just translation into another language. There are circumstances where it's double translation on to some of the other European languages. And you learn that, well, none of the rhetorical flourishes work, because this has to be something that can be translated twice. And in a way, what we're doing here needs to be something that works, I think, at its core and clearly, and that doesn't involve the thing that we like as lawyers, perhaps, the sophistication at the margins.
Well, thank you very much. Merci beaucoup.
Quelle belle séance nous sortir de notre paroisse, n'est-ce pas, là, un tout petit peu, là, qui, pour terminer notre journée, vous nous avez ouvert les yeux de manière inopinée, je dois dire, sur la justice internationale. Merci, chère Louise, chère Donal, chère Hélène, là, c'était magnifique, votre séance. I would ask colleagues to join me in offering warm, we're tired. It's been a long day. I don't think we want to welcome, because always we have to start all over again. How about warm thanks to our panelists for their superb work. On vous remercie et on va tirer la journée à sa fin avec éventuellement un mot de notre juge en chef.